Now, the other way cannabis businesses are getting around Section 280E is allocating expenses as costs of goods sold. Now, while on its face, Section 280E disallows cannabis businesses the deduction of all business expenses, business owners have used cost of goods sold to their advantage. Now, cost of goods sold, we'll call it COGS, those are the costs of acquiring inventory through purchase or production, including shipping costs and directly related expenses. Taxpayers, regardless of what business they're in, use this formula to calculate gross income, gross receipts minus COGS. Now, Congress did not disallow COGS deductions in 280E because it feared possible constitutional challenges to the law, and we could see this in a case Eisner versus Macomber. Here, they denied deduction for COGS because they thought that the affected business to be taxed on an amount in excess of his income would go beyond the 16th Amendment. We also have basically a bunch of constitutional arguments arguing that if they disallowed COGS, it would be a violation of the Constitution. So the IRS and the U.S. tax courts permitted cannabis retailers to deduct their COGS because of a historical view that COGS are a component of gross income and not a deduction by themselves. Some would argue this is actually a pro-cannabis business tax provision because it allows the business owner to recover some, though not all, of their business expenses. Now, while this argument is valid at the macro level, this is only a small triumph because the majority of business expenses are not deductible under COGS. Not only are COGS a minor part of cannabis business expense, the IRS employs the COGS exception more narrowly to cannabis businesses compared to businesses in mainstream industries. The IRS prohibits cannabis businesses from using revisions to the code that were enacted after Section 280E went into effect. So in 2015, the IRS, they released an internal legal memo outlining a strict interpretation of Section 280E when applied to cannabis businesses. Though this memo may not be used or cited by taxpayers as legal precedent, saying that it holds weight in court, the memo does outline how some IRS officials analyze Section 280E and how they determine COGS. This prohibition forces cannabis businesses to use outdated versions of the code, which is unfair because other businesses, including other illegal ones, use updated taxpayer-friendly accounting laws. Now, when calculating COGS, cannabis businesses are forced to use Section 471 of the code. Section 471, which was in place when Congress enacted 280E, instructs retailers to calculate their COGS as any direct costs they pay for inventory, the invoice price of goods, plus any transportation or any other necessary charges in acquiring possession of the goods. So cultivators, under Section 471, they must include both direct and indirect costs of creating their inventory in their COGS calculation. Now check this out. Section 263A, which was enacted 4 years after 280E was enacted, expanded to 471. Section 263A broadened the definition of indirect costs and gave retailers the ability to include indirect inventory expenses in their COGS. Section 263A allows businesses to capitalize on indirect costs. So some of these examples are administrative and inventory costs, as well as the amount paid in state excise taxes, and they could deduct them under COGS. The goal of this expansion of 471 was to treat taxpayers more fairly, but U.S. tax courts are not willing to allow cannabis businesses to use Section 263A. Now, under the 2015 IRS memo I mentioned before, cannabis businesses are required to calculate COGS deductions using the regulations under 471 and not the new accounting methods other businesses have access to under 263A. Isn't that crazy? The memorandum outlines a very narrow reading of the costs included in COGS because it suggests the IRS will not allow cannabis businesses to allocate those indirect costs, such as purchasing, handling, storage, into COGS. Now, other than this memo, the IRS has not offered much guidance regarding the application of Section 280E. Now, there's a big gap in understanding, and with this gap, it's up to the courts to outline the fairly narrow parameters of 280E. Now, this issue was the focus of an important case, Mutt Assistance Collective Corp versus Commissioner. Now here the petitioner was Harborside, which arguably is the most famous medical cannabis dispensary at one point in the United States. They've been in battle with the IRS since 2010 over a $36 million tax bill. From 2007 to 2012, Harborside calculated their COGS deductions using 263A of the code. The IRS argued that Harborside had to calculate their COGS using Section 471. Remember, the outdated part. The tax court held Harborside could not use Section 263A because that section did not apply to drug traffickers under federal law. And because federal law labels Harborside as a drug trafficker, Harborside must calculate under 471, that is, calculate their cost of goods sold under 471, which does not include the indirect business expenses. In this case, the court concluded that Harborside was a reseller, not a producer. Now, this conclusion is important because Section 471 rules, those rules that apply to resellers do not allow for extensive indirect costs to be included in inventory that the Section 263A rules do. This holding that the more expansive Section 263A does not apply to businesses subject to 280E is not favorable to cannabis businesses whatsoever. But the holding does provide cannabis business owners much needed guidance regarding 263A's interaction with Section 280E when calculating COGS. Here's the conclusion you could take from this case. Resellers face significant challenges by the IRS if they include indirect costs in inventory. But still, cultivators and producers must carefully consider how Section 471 applies to their business, depending on their business's activities. Now, Harborside was left with two options. They could pay their tax bill or appeal to the U.S. Court of Appeals for the Ninth Circuit. Given the amount of money at stake, I'm not sure what the update of the case is, but Harborside should definitely appeal to the Ninth Circuit. I think there's a respectable chance Harborside could win on appeal because Harborside is not trying to reverse any finding of fact by the lower court, which is a high standard to meet. Rather, Harborside would appeal the legal application of Section 263A. The tax court hinted there might be some relief when it stated that the overlap between Section 280E and 263 created a confusing legal environment. The Ninth Circuit could be more sympathetic to Harborside, but I think based on my research, Harborside has yet to appeal. Although the Harborside case did not set legal precedent, the holding opened a new avenue for cannabis businesses to consider when calculating their COGS. Permitting cannabis businesses to use Section 471 forces cannabis businesses to use savvy accounting methods to try and fit more of their expenses into COGS in order to avoid the lack of deduction opportunities under Section 280E. This puts state legal cannabis businesses in a peculiar position. Generally, a taxpayer would prefer to deduct an expense in real time rather than capitalizing it through COGS. Why? This is because a current deduction immediately reduces tax liability, whereas capitalizing the expense delays any deduction until the goods are actually sold. Thus, the state legal cannabis businesses are forced to throw everything they can into COGS. This approach is risky and can lead to severe consequences. Harborside's $36 million tax bill is just one example. Will cannabis businesses be treated fairly one day? Maybe. There are arguments that have not been made. For example, that the congressional intent behind 280E has not been met. It wasn't until 2015 when the courts first considered the congressional intent of Section 280E and whether applying Section 280E to state legal businesses aligned with that intent. In an appeal of the 2012 Olive decision, Olive argued that the application of Section 280E to cannabis businesses didn't align with the intent of 280E to deter illegal drug use, which is a main point I've made here in this episode. But the Ninth Circuit Court of Appeal was not persuaded, and they actually affirmed the tax court's decision. Written law governs tax enforcement. Yet the U.S. Tax Court and United States Supreme Court always interpret the text of the statute to some degree of interpretation not included in the text. That's the whole point of judges. The Supreme Court usually interprets the code to carry out its legislative purpose. Thus, they usually read actually beyond the plain meaning of the code. When the language and suggested purpose of the code conflict, the Supreme Court is willing to interpret the provision to align more closely to the provision's purpose rather than a literal reading of the provision itself. The legislative history of Section 280E suggests the drafters envisioned 280E to deter illegal drug trafficking, not cripple state legal businesses. When taking the code on its face, when reading it on its face, Section 280E seeks to deter illegal drug use, but when it is applied, it has little connection with the original intent of the rule. Revising 280E would advance Congress's intent to deter illegal drug dealing because it would help the legal marketplace compete with the black market. I think revising 280E would also restore fundamental fairness by assessing income tax on income for all businesses legal under state law.